This is SJC-12677, Commonwealth v. Andrew Robertson.
Okay, Attorney Marski, good morning.
Good morning, Your Honor. Good morning, Your Honors. May it please the court, Attorney David Mirsky for Andrew Robertson. First, I'll address Mr. Robertson's convictions. His first-degree murder and illegal possession of firearms should be dismissed because retrial after jury deadlock, where the evidence was insufficient to prove guilt beyond a reasonable doubt, was barred by double jeopardy. The Commonwealth conceded that no witness could identify Mr. Robertson or anyone from the surveillance video they were relying on to prove the identification of the alleged assailant. And there was no evidence of that, and the only evidence that came in was not proper evidence. It was not actual evidence. It was argument by the prosecutor, which was improper, which is also a separate issue, but it's not even evidence because it was just argument. And the prosecutor attempted to make the identification from the video, but could not. There was no evidence of that. And then there's an ineffective failure of trial counsel to object to that. The Commonwealth conceded that they did not have that evidence. In terms of the double jeopardy issue, the Commonwealth has raised very briefly in their brief, without any citation, that a double jeopardy issue is waived because not brought before, not appealed after the motion to dismiss was denied in the trial court. However, the motion to dismiss was denied. It was raised post-trial. The objection to the evidence was raised in the first trial as being insufficient to prove guilt beyond a reasonable doubt. The objection was raised to retrial in the motion to dismiss, which was filed after the evidence, which came before the transcripts were fully prepared. And in Clark, this court has stated that double jeopardy, and quoting Preston, can be raised at least as well in the appeal following the second trial as under General Laws, Chapter 211, Section 3, which is also not a mandatory statute anyway. It's a enabling. It gives the opportunity of the court. It does not preclude or force a defendant to waive important constitutional rights.
Mr. Mirsky, if you're
Yes.
if you're wrong on, if you're right that it's preserved but wrong on sufficiency at both trials, what's your issue that you want to discuss first?
Well, I don't concede that, Your Honor, but
I know you
obviously.
don't. I understand.
But the issue that I think is the most important, other than those, is the fingerprint evidence. The Wadlington issue, saying that the Commonwealth, the court and the Commonwealth were allowed to put something in as a fact, which is not fact under Massachusetts law, under this court's law, which is fingerprint identification evidence. It's not supposed to be presented as a fact, and it was at trial. They presented evidence from the testimony of Ms. Koziorek that they were able to individualize fingerprints, that they were able to exclude and identify definitely people from fingerprints. However, the That's not
I'm sorry to
valid.
interrupt you, but before getting to whether or not the opinion given violated Fulgham and Drayton, are you arguing that this is preserved because the issue that was raised was Delbert Lanigan, not the certainty of the expert's testimony on fingerprints?
Well, Your Honor, the evidence, the evidence is preserved because it was part of a pretrial motion objected to at this, taking in account that this witness testified in the first trial and gave these type of opinions in the first trial, and everyone knew, including it was on the record, that this is impermissible. That's not fact. It's not fact. So they're not permitted.
I understand, but I thought the objection on the fingerprint evidence was that we had a motion on was as it related to gatekeeper reliability.
Well, Your Honor, the reliability is in the motion. It is in the objection, which is the raised that there's no statistical basis given to evaluate to the jurors to evaluate the significance of the fingerprint evidence in terms of identification of an individual, that you cannot, this is not evidence, it's just an argument by a prosecutor, person who works for the prosecution team, and it's not meeting, it would not have stood up to Delbert and Lanigan. It would not have stood up to an evidentiary hearing. Attorney Scapiccio submitted attachments to the motion, which Mr. Robertson joined, and which was the joinder in all co-defendant motions was permitted and acknowledged by the second trial judge. And that NA's report, it's in the appendix, and also reiterated and validated by subsequent findings of the National Academy of Sciences on this matter in the September following the convictions, that this would not have stood up, okay, to a Delbert Lanigan hearing, and the judge, that the arguments were made and the evidence was there on the record, making the beginnings of making a prima facie case of the evidence, more than a prima facie case, the actual evidence. I've attached it to the record appendix. I
read the whole fingerprint transcript, and I certainly understand your argument. Assuming, I'm not sure it was preserved. I think what was preserved was Delbert Lanigan, and Mr. Mitchell conceded the fingerprint issue in the closing and alluded to conceding it in the opening. But putting that aside, when is it that the expert comes out and actually says that he's testifying not to an opinion, but to an infallibility or to a certainty? When is that ever part of the answer to a question?
That's all through Deborah Koziorik's testimony, Your Honor, saying that fingerprints were individualized to Mr. Robertson, that she can make a conclusive statement on whether a person
conclude. First of all, individualized was even in Commonwealth versus Fulgham. As long as it's clear it's subjective, you can use the word individualized.
But it's not clear. It's not clear that it's subjective. It's not only not clear, it's not the way it was presented by the Commonwealth in closing. It's not the way it was presented at trial. In either trial, but I'm talking about the second trial here because there was convictions. this was presented as fact, which it's not fact. Okay, I argue that it's not even permitted to consider this as a fact that was presented in the first trial, because it's not fact. It's not fact. You can't. It's been already found by this court that it's only an opinion, and it cannot be considered a fact at all. To consider this type of individualization and conclusion, evidence can be concluded from the type of whorls and finger, I know it when I see it testimony that's given here by Deborah Koziorg. That is not fact. Okay, so it would be
So
when
I understand what you're saying. I'm wondering how you distinguish the Drayton case.
Drayton.
Yeah, that was the case where the expert testified that she individualized the fingerprints at the crime scene to the defendant's right middle finger joint. As I read the case, that was perfectly fine. How is the testimony here different? I'm not suggesting it's not. I just don't see the difference. I'm asking you to.
Well, in my view, Drayton is not correctly presented in the Commonwealth's brief. The court in Wadlington warned that evidence, that testimony to the effect that a print matches or is individualized a note print should be presented as an opinion, not a fact, not a fact. So when the prosecutor is arguing, as he did actually in the earlier trial, that you can reflexively justify his arguments of who the person is in the video based on the fingerprints, he actually is inventing a type of science that doesn't exist. It would be like saying, I have a new way of proving identification by breath or something. Okay, it's a completely made up thing under this standard. It should not be presented as a fact, and it's being presented as a fact. And the case, the material that I've submitted in my reply brief as the September 2017 reiteration validation of the National Academy of Sciences report shows that the scientists in the community of scientists do not consider even that to leave that impression and to give a jury to make that impression with on the stand to even be accepted at all within any community. It's not accepted. It doesn't meet Dober or Lanigan. That's how it's not going to make it. It's not accepted. It's not valid. It doesn't allow a scientific judgment to be made. It doesn't allow, you can't say, I know it when I see it. Okay, we're not talking about that. We're not talking about a judgment of what's pornography. We're talking about identifying a person. And this isn't permitted here. And this court has said that in Wellington. And to use Drayton otherwise, whether it was used in other ways, that's just wrong. And the science has to be looked at. And this court has also said that the court can take notice of the science in the state that it's in. And I'm giving you that by the cite to the updated September 2017 report, Your Honor.
Mr. Mirsky, and it's not in your brief, but the photos of the surveillance video that were admitted in evidence, the judge gave a limiting instruction when that came in, that those were only admitted on Bowden as it related to the investigation. How does that change your argument on any of your issues?
All I'd say, Your Honor, is that the judge acknowledged there was no identification. That's why no identification instruction was given. That's what she said. No one.
No, I'm sorry. I'm sorry. You know how there was the video evidence that came in only under Bowden? There were photos from the surveillance as well that were admitted. I'm not talking about the comparisons at this point. I'm talking about, but when the photos came in from the video, those photos came in with a limiting instruction that they were only admitted under Bowden. How does that change your argument?
Well, Your Honor, if they're not admitted to identify the defendant, well, what's the point? What is the point of that, of photos? I have an issue on a witness who claimed he was claimed he wasn't altering photos. However, in the Commonwealth's brief, the Commonwealth acknowledges that he altered photos, and that when he did that, he was trying to, as would be done, by a prosecution employee, he was trying to focus on making it look like a certain person from a very distorted image. And you don't have these identifications, Your Honor. And but if Bowden doesn't change what I'm saying, I don't need to say, I don't need to criticize the police. They don't have the evidence. Okay, the prosecutor said they don't have it. They didn't have it. And unless there are any other questions, Your Honor, I'll rest on my briefs, both my principal brief and my reply brief and my record appendix. Thank you, Your Honors.
Okay, thank you very much. Attorney Jordan.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth, and with us via Zoom is the trial prosecutor, ADA Ian Pallenbaum. The Commonwealth is asking that you affirm the defendant's convictions here and his part in executing Romeo McCubbin on December 14th, 2013. I just want to point to the fact that the Commonwealth does think that the first issue is waived regarding the defendant's failure to appeal to the single justice after his motion to dismiss was denied by Judge Sanders. The cases cited by my brother, Clark and Berry, are all decided in 1985. This court later in 1987 clarified what the proper procedure was in Chatfield Taylor, which is at 399 Mass 1, Penn Site 3, 1987. So, and if I can read from it, the court says the appropriate procedure to obtain review of the denial of a motion to dismiss on the ground of double jeopardy is to petition for relief from the single justice pursuant to 211(3). And also just to compare and contrast, all the cases cited by my brother, that's Berry, Clark, and Preston. In those instances, a 211(3) was filed in all of those instances, and the procedural history is different. In some of those cases, and I think it's Preston, the initial motion to dismiss was actually decided on Rule of Criminal Procedure 25. So when it came upon review, there was a procedural difference there. And in Berry, the single justice, after reviewing the 211(3) petition, actually appealed it to the full court without an opinion, and subsequently the defendant was tried again in the second trial. So I just think procedurally it's different, and that's the side I cite to. But all that being said, even if the court were to address the merits of the case, it is clear that there was sufficient evidence in the first case to prove the defendant's identity as the first shooter. And I do want to point out the evidence is very similar, almost identical in the first and second trials. And my brother focuses on the testimony of Takara Rice, who did view photos. And as I explained in the brief, Takara Rice knew the defendant prior to this case, had personal knowledge of him, had explained to the jury she had known him, and I think had met him in the past, I think 7 years through basically a boyfriend, and that her awareness of the defendant being present at the club before the murder, she herself was looking through Facebook photos and it came to her own attention. So this wasn't an instance where as I think my brother tries to paint, where the government was feeding Miss Rice the identity of the defendant as the person in the club photos, which again, the Commonwealth then corroborates as the shooter through the booking photos and the surveillance. Moreover, there's a lot of corroborating evidence that was the defendant that was the shooter. We have the fact that he and the defendants spoke, corroborated, were together at the club beforehand. We have the defendant's association with the MRX, the SUV driven by Watson in the moments before the murder with the RAV4, which Commonwealth thinks basically they were doing surveillance to see where the victim was parking. And then moments later, we see Watson drive the defendant up to the victim who's sitting unsuspectingly in the car and riddle him with 9 bullets and get back in that car. And we know that there's fingerprints associated with all 4 of the co-defendants as well. Yes.
On that point, on the 3rd day of impanelment, Commonwealth versus Fulgham came out. And what Commonwealth versus Fulgham said is it must come out clearly through the expert's testimony that this is a subjective opinion. And saying we conclude or individualized does not clearly indicate this is a subjective opinion. Now, I recognize that very shortly before that, we had Commonwealth versus Drayton, and the Gambora language comes from the concurrence. So I understand that it's not crystal clear what our fingerprint evidence was, but during impanelment, we're hearing clearly indicate that this is a subjective opinion. Doesn't that require the prosecutor proactively point out if the witness doesn't say it with some sort of question? You're giving an opinion here, a subjective opinion here.
Of course, that would be great. I don't disagree with Your Honor whatsoever that, of course, that would be best case scenario for the prosecutor to do that. But as you pointed out, this happened during the course of the trial, and I by no means excuse that. But I think the fact how the testimony does come in is that even if she uses, actually, I should also mention that the word individualized is actually not introduced by Kishoric. It's actually introduced by the prosecutor. I know that's splitting hairs, but I do think in a way, this kind of goes to the point that this was the language being used essentially at the time of trial and being used appropriately. Kishoric only says concludes, and on volume 12, pages 218 and 219, she does a very good job of explaining this defendant's fingerprints and how she looked at which swirls and which not. So I don't think it's necessarily, I don't think it can be ambiguous that Kishoric as the expert, what she did. So even if maybe we're not using the buzz language in the way that Fulham eventually says is, almost shores up Gambora, I don't think at the time of this trial that it was erroneous. And I also want to point out that Kishoric never says, I look at these and I exclude everybody else. There's none of that, if you will, absolute or concrete kind of affirmative language that before Fulham, this court frowned upon. So I couldn't find a case where it was just the word individualized with no other words except for Drayton. And I think the fact of the matter is that Kishoric's ability to explain her opinion, again, removes what she did. So it's almost like, not who cares what the words are obviously meaningful, but the fact that she explains how she comes to her conclusion, I think is meaningful in the way this evidence is viewed. And I do want to point out that she does explain that the fingerprints are fallible. I think there was no contemporary objections and there was no vigorous cross-examination. And I bring that up.
That doesn't really help. And that doesn't really help because there sure was in the first trial. And it seems like the judge is they're rushing at the end of a murder trial. Everyone's rushing at the end of a murder trial. If you read this transcript, never a good idea. So the fact that there's no cross-examination doesn't help the Commonwealth in the analysis.
But I appreciate bringing up that point, because I do think if you compare how all the forensic evidence came in the first trial, if you compare it to how the fingerprint evidence is treated in the second trial, I suggest if you really read through the whole transcript, what the strategy was to, if you will, prop up all the forensics experts, the gunshot residue expert, the fingerprint expert, as comparative to the ballistic evidence, which was admitted by Detective Martin Leiden, who did not have a college degree, who didn't have all this kind of science and aura around him that they did. So I suggest this was actually strategic, and to kind of not challenge all this other forensic, to compare and contrast in order to really hit home the ineptitude, as I think that they argue, as especially Attorney Scrishu argued regarding the ballistics and the weight given to that. So I think in a way it's strategic, and I think the only way to kind of understand that contextually as strategic is by looking at comparing it to the first. So just
preserved. I'm sorry, I should have asked you this first. Was the expert testimony objection preserved?
My reading of the transcript is the only thing that was preserved, as you asked my brother, was the Daubert Lanigan challenge, based on the language. The NAS. I'm probably messing that up. That study. My reading of the and this was heavily litigated in a motion to eliminate, and there was no objection contemporaneous with any of this language of individualized, of concluding, or at the end in conclusion of Ms. Kishorik's testimony. There's no motions to strike or anything of the kind, and that's again why I bring up maybe the strategy, and then looking at the closing arguments, how at least Mr. Robertson's attorney argues fingerprints. It's not this heavy hitted home thing. This is almost a blip, because as we've already discussed, there's much other corroborating evidence that this is the defendant as the shooter. We have the photos, we have the call made from Denton calling SP after he's been arrested. We have the defendant canceling his phone the day after the murder. We have the images of him shooting, comparing his clothing, his facial hair. So I think when we look at this bigger picture, yes, this is absolutely strong evidence for the Commonwealth, but this isn't the only evidence of identity. And I think if we look at it from the strategic point, as I pointed out, as well, that I don't think the prejudice is as strong that this would require a reversal of the convictions.
What legal authority are you relying on for the notion that we should compare the first trial and that strategy to this trial in this strategy in order to determine whether there's a substantial likelihood of a miscarriage of justice?
That's a fair question. I don't have a legal authority. That was more me preparing for these cases and the argument and having argued the other cases in front of this court. So I don't necessarily have an argument to maybe contrast and compare, but I think if this was presented as an ineffective assistance claim, then we could look at it that way. So I don't see how this court can't look at a strategy, even if in isolation, even if we just looked at this transcript, you can still compare how they treat Detective Leiden's testimony. Detective Leiden is vigorously, for volumes almost, cross-examined on the ballistics. And here we have this unobjected to, no motions to strike in the latent print expert's testimony. So so that's as best as I can answer Your Honor's question.
Thank you.
If you go to the comparison of the enhanced photographs and the points of comparison, it's true that most of the testimony is a juxtaposition of the two, and the judge gives an instruction that the expert's not to give an opinion, and the prosecutor has prefatory comments in his questions. But despite all of that, the witness says at one point, I was looking for similar features in each picture. You can't do that. That's what the jury does. What about that issue?
Well, I think I did read that as his testimony, and I think if I remember correctly, that might have been a cross-examination where
No, the prosecutor says, and it's true now, we can't get into whatever your opinions might be. That's ultimately for the jury. But were you looking to juxtapose certain points of comparison in the picture? Perfectly permissible question on 515 on page 88. But the answer is, I was looking for similar features in each picture. That's what the jury does.
Mm-hmm. I don't disagree with you. I think if anything, maybe that was not eloquently said. I think the jury knows that John Green doesn't know these people, that John Green was given photos and I think he testifies, they just gave me the photos. I think he himself is looking for similar points and not necessarily, fed by the police or the prosecutor what those similarities are. I think the way I understand that is that I looked at similarities to try to figure out if this is even makes sense to or is helpful for the jury. Is this even, that's more to me. And I'd say I was looking for whether or not things are relevant to even contrast. So, and I think the language, I know like the languages around these photos, enhanced, altered, it's almost, we use it colloquially, but I think when you really think about, and the expert testify this, it's like the old fashioned TV where you're turning up the contrast and down, where you're not changing the image that NBC put on, but you're really just changing it on your monitor. So I just kind of want to be clear on that.
But your point, so I can make sure I understand it. You're saying that when the witness says, I was looking for similar features in each picture, Mr. Green's not saying, well, I was looking and the left arm matches and the wrist tattoo matches and the clothing's match. Your view is that testimony is that he's just saying, well, I was going back and forth and looking to see if there was similar as a foundation.
Yes, saying
but don't we have arrows? Are there arrows in the photograph?
So yes, I agree with your first point that he wasn't saying, the hairline here matches with the hairline here. He was saying what I did was zoom in on the head to focus on the hairline. So I agree with that. He wasn't making a conclusive statement that these indeed are similarities. And I'm sorry, what was the
were the arrows pointing?
Oh, the arrows. The arrows were admitted as identification. They were not published to the jury. So I think they were more illustrative of this is the methodology that Mr. Green was using. And to illustrate his point was, I looked at similarities here and here, as opposed to saying, it's up to you, can figure it out. I mean, the jury had all these photos and could compare or contrast or not use them at all. They could have just used the photo from booking and disregarded all of Mr. Green's testimony and still came to the same conclusions with none of the, if you will, contrasted photos.
Well, the reenactment photos from the video, they came in when I think Judge Giles first talked about them being admitted. They were different than the Bowden on the surveillance. But when they were admitted, she gave a limiting instruction that the reenactment photos weren't they were only in under Bowden for the investigation. Does that change any of the defendant's arguments?
I'm sorry, by the reenactment photos, are we talking about the photo or the video that was taken 4 days after the murder?
Right.
Okay. Does it change it if it's only for Bowden? I would suggest that it doesn't really change how, if the Commonwealth is only, the jury is only allowed to use it for the purposes of what the detectives did next. I guess that could alter how they use that video. But if I remember correctly, then she didn't
mention it in the final charge. I guess there's two things. One is it's argued in the closing, I think briefly, the enhanced photos. So that's an issue to think about, I guess.
I think at the end of the day, even if we have this advanced, let's say it's only used for Bowdoin, it educates what the detectives did next. And I think the jury can take into consideration that even if they don't see those videos, they hear testimony that the MRX was later linked via a rental agreement back to the defendant. They also hear evidence that the RAV4 belongs to Bonner's sister, Sophia, and she testifies that that's her car. So even if there's limited to, what the jury could properly use it for, I think there's other evidence that would corroborate that these cars that, were identified by the police. So even if I guess my point is, even if the police did this purposeful drive using the same video cameras, using the same, lighting, or, with a slight variance, that if that was meaningful for the detectives to then later make those connections back to Watson and back to Bonner through other chains of evidence, then I would think that would be that would be permissible and proper. I know that was a long way to answer your question.